Hello everybody, welcome to ixam's Legal Bee. This is Amrita, your law faculty, and in this video I am continuing the series of previous year questions of SEBI Grade A Legal Officer examination. In previous videos we have covered questions from the topic of company law, contracts, constitution, securities law. Now in this video I have picked the unit of Criminal and Procedural Laws. So don't forget to subscribe and stay tuned with such kind of updates, beneficial videos and content. Let us quickly start the discussion. The questions that I have picked up is previous year questions that have been picked from 2020 and 2022 previous year papers. So you can download the papers, you can go to the website www.ixam.com and solve all these questions also. Also, you can solve mock tests for free at ixam.com and take benefit of all these practice questions as these give you an exact idea of how you have to expect questions in the examination. In the unit of Criminal and Procedural Laws, IPC, CRPC, evidence and CPC will be covered. You can see this third, fourth and fifth number in syllabus. Phase 1, 15% weightage. Phase 2, it is having 10% weightage. Altogether, you can see weightage is being lessened in phase 2, but it is still an important unit. Many questions are asked, and moreover, these questions are scoring in nature. So, do focus on this unit and cover all these questions. In phase 1, you can expect around 7 to 8 questions, and phase 2, you can expect around 5 questions. First question, what can a civil court do in case resistance is caused to execution of a decree by judgment debtor? Order that decree holder be put in possession of property. Order civil prison of 60 days maximum to the judgment debtor. Order civil prison of 30 days maximum to the judgment debtor, A or B, A or C. And the answer is A or C. Section 74 of CPC talks about this concept. 30 days civil prison can be given, or an order directly can be given that the decree holder be put in possession of property. Execution is an important topic. Next question, what are the kinds of punishments provided under IPC? Death penalty, imprisonment, life imprisonment, capital punishment, death penalty, life imprisonment, simple or rigorous imprisonment, fine, forfeiture of property, C and D. And the answer is C and D. There are 5 different kinds of punishments that are awarded by the IPC under section 53, and they are death, life imprisonment, simple or rigorous imprisonment, fine and forfeiture of property. Which of the following options talks about a cognizable offence? Now another important topic from CRPC, where a police officer can arrest without warrant. During pendency of trial, bail application can be moved before the concerned magistrate. Only victim can make a complaint to the magistrate. A and C, A and B. We can make out from the options only that third option is not relevant, but first 2 are relevant, and the answer is A and B only. How many criminal courts are constituted under CRPC? 5, 4, 3, 6, 2. A very easy question, I would say, but still people can get confused. Don't consider in this CRPC, High Court, Supreme Court have not been covered. Criminal courts as per CRPC, Sessions Court, Judicial Magistrate, Metropolitan Magistrate, Second Class Magistrate and Executive Magistrates have been recognized. So the number comes to 4. Which provision deals with means profits? Means profit is another important topic from CPC. And here they have asked you section. They can also ask you some question relating to interest on means profit and so on. So refer section 2 clause 12 of CPC. That is the correct answer to this question. And it talks about means profits. Important topic. Again and again I will tell you. Do mark this and study it well. Court need not frame charges in which case? Warrant case without a police report, with a police report, summons case, summary trials. Now this is a question which you can apply a simple logic that when court does not need to frame charge, in which kind of case? And the answer is E, summary trials. Section 251 of CRPC talks about summary trials. These procedures of trials are very important topic from CRPC. You can expect any such kind of question. summary trial, session trial, warrant trial. All these trials you can go through once and have a clear conceptual clarity on it. Court shall take judicial notice of certain facts. Which of the following facts is not included? Geographical division, territories under dominion of Government of India, existence of title and national flag of every state or union or sovereign, public festivals, fasts, holidays, all are included. So court shall take judicial notice of certain facts. Which is not included has been asked. But out of these options, the correct answer is that all are included. Very direct question, section 57 of Evidence Act you can refer for this purpose. If the offence be punishable with imprisonment as well as fine and the offender is in default of payment of fine, then the court may direct imprisonment for a term, 1/3 of term of imprisonment of fine of maximum offence punishment, 1/4 of the term of imprisonment of maximum fixed for the offence, 1/4 term of imprisonment already been subjected to, 1/3 of imprisonment which has already been subjected to, equal to the term of imprisonment which he has been subjected to. The correct answer is B. Section 64 and 65 of IPC deals with it, that 1/4 of the term of imprisonment which is maximum fixed for the offence, that has to be that has to be undergone by the offender if he has not paid the fine. 1/4 of the term of imprisonment which is maximum fixed for the offence. Where immovable property is sold in execution of a decree and that sale has become absolute, then it shall be deemed to have vested in the purchaser from the time. From when it will be vested in the purchaser, that they are asking. Again a question from execution. When the property is sold, when the sale has become absolute, when actual transfer of property takes place, when decree is made, when decree is executed. A very simple question, you can apply your own logic also, that when the property is sold, from that time only the property will be vested. And section 65 of CPC is talking about this concept. Whenever immovable property is sold in execution and that sale has become absolute, property shall be deemed to have been vested. Sale has become absolute will be the correct option over here. Since property is sold is correct, but the most appropriate answer will be B over here. That is when the sale has become absolute. At that time it is deemed that the ownership has transferred. If the ownership has property shall be deemed to be vested from the time when property is sold and not from the time when the sale has become absolute. This is specified in section 65 of CPC only. We may get confused in these options, but you have to read the entire section properly for this purpose. That property shall be deemed to have vested in the purchaser from the time when the property is sold and not from the time when the sale has become absolute. It is specified over here in the section itself. So the correct answer will be A, when the property is sold. A obtains property from Z by saying, your child is in the hands of my gang and we will put him to death unless you send us 1 lakh rupees. In this situation, which of the following offence has been committed? Robbery, extortion, kidnapping and extortion, robbery along with element of extortion, kidnapping and robbery. Now this is an illustration based question. IPC you can expect such kind of questions. Extortion is the correct answer. It has been picked from the illustration under section 390 of IPC, which is distinguishing robbery and extortion very clearly. A sessions court requires permission of High Court to pass sentence of death penalty, sentence of life imprisonment, sentence of life imprisonment with hard labor, rigorous imprisonment with solitary confinement, any sentences that are having the punishment of death. Interesting question, and everybody generally has an idea of this. For passing a sentence of death penalty, confirmation by High Court is required as per section 366 of CRPC. Here you should remember the provision also. You can check out the section. Certified copy of a document is an evidence. Then which type of evidence it is? Not an evidence, certified evidence, oral evidence, primary evidence, secondary evidence. Very easy, secondary evidence. Within seconds we can answer this question. Section 63 of Evidence Act. Arrest in cognizable cases can be Made without warrant, made with warrant only, made with warrant for offences above 7 years, made without warrant for offences of trivial in nature, none of the above. Answer is A. This is the very basic feature of cognizable cases, that arrest can be made without warrant. As per CRPC section 151, arrest to prevent the commission of cognizable offence is the exact provision which is talking about this. Can a dumb person be a witness? No. Can, as per section 19 of Indian Evidence Act. Can be a hostile witness, can be a witness simply, can be as per section 119 of Indian Evidence Act. Now this looks confusing even if you remember the provision number, but yes, it is not 19, it is 119 of Indian Evidence Act, which is directly talking about dumb witness. We are having a direct provision of it, and the concept of hostile witness, all these things are very different than this. So refer provision, it is important. Who is unable to speak and still he can give his evidence by signs or something like that. So that is known as a dumb witness. Confession in front of police officer is valid when it is valid, not in any circumstances. Valid when corroborated with other substantial evidences. Weak evidence. Valid if it is in the presence of magistrate, valid if taken in front of an independent witness. And the answer is D. Valid if it is in the presence of a magistrate. Section 25 of Evidence Act talks about that the confession, if it is made to a police officer, it is not to be proved. No confession made to a police officer shall be proved against a person accused of an offence, and it shall be proved as against a person who is accused of an offence if it is made in the presence of a magistrate. A decree holder is any person in whose favour decree has been passed, in whose favour interim relief is granted, who is in debt by the decree, against whom decree is passed, who does not get decree executed. Very simple. First option itself is correct. Section 2 clause 3 talks about decree holder. Who is he? In whose favour decree has been passed, and judgment debtor is whom against the decree has been passed. What is the age of a juvenile offender as provided under CRPC? 16, 21, 18, 16 for males, 18 for females, 16 for females, 18 for males. Now the correct answer is 16. Juvenile offender, A is the correct answer, 16 years. Section 27 is talking about this particular aspect. 16 years has been set, and it is not different for male female. Court may compel attendance of any person to whom a summons has been issued. For this purpose, a maximum fine can be imposed to the tune of 5,000, 1,000, 3,000, 2,500. Now, is there any such kind of fine fixed? Yes, it has been fixed as per section 32 of CPC. Penalty of default has been discussed. Court may compel attendance of a witness, and for that 5,000 rupees fine has been fixed by court, not exceeding 5,000 rupees. That is provided under section 32 clause C, subclause C. If the judgment debtor obstructs delivery of possession of property, then court can order detention of the judgment debtor. Court can make an order for detention of JD at the instance of decree holder. Decree holder has to make an application for arrest of judgment debtor. A and B, any of the above mentioned modes can be adopted for this. Answer is B. Court can make an order for detention of JD at the instance of DH. Obviously, that has to be at the instance of DH. This question, many people got confused, but this is simple question only, that order of detention can be made in such kind of property if he is physically obstructing the delivery of possession, and that will be at the instance of DH only as per CPC. As per CPC, all the expenses have to be borne by whom? They have to be borne by decree holder only. It is a civil prison, and the concept you can easily logically apply your mind and don't get confused much when you are reading the options. And again, I'll remind you, CPC is a very important topic, out of which CPC has many questions from execution. Please take note of that. Section 51 is talking about this powers of court to enforce execution. You can go through this section in detail. It is a very important section. A woman has thrown acid on a man and that man has gone to the hospital, but the hospital has refused to admit the man. Then what will be the scenario in this case? Hospital will be forced to admit and treat the victim. Man will not be treated. Hospital will not be liable, as the victim is not a woman. Victim is not a woman. Hospital will be liable to punishment under IPC. Hospital will be liable to inform police about the man. All of the above are correct. Answer is C. Hospital will be liable to punishment under IPC. Section 166 clause B of IPC has been amended and added punishment for non-treatment of victim. And now the hospital has to treat the victim. It is their prime duty. For that, it has been made an offence and imprisonment up to 1 year, or with fine or with both it has been made punishable. Remember the provision also, remember the punishment also. The thief, in order to steal something, creeps after sunset into a ship at a porthole between decks and then leaves before sunrise. He has committed what? He has committed house trespass, housebreaking by night, lurking house trespass, no offence. Now these are the concepts that we get confused. What is house trespass? What is trespass? What is housebreaking? What is housebreaking by night? What is lurking house trespass? If अगर आपकी ये concepts clear है तो आप यहाँ questions बहुत easily answer कर सकते हो. And you can check out IPC में से इस तरीके के situation based, illustration based questions काफ़ी पूछे गए हैं. Answer is C, housebreaking by night. After sunset दिया है तो automatically you can apply the logic that it is housebreaking by night. Illustration to section 445 and 446 of IPC is talking about exactly this situation. If the court has asked for production of a document and the person does not produce it, then what shall the court presume in such a case? Document is certified, it is genuine, it is attested, stamped, executed in the manner that is required by law. Document is duly signed. Document does not exist at all. Answer is C. Document was attested, stamped and executed in the manner required by law. The court will presume that. Section 89 of Indian Evidence Act is talking about presumption as to due execution of documents that are not produced. Court will presume that it has been duly attested, stamped and executed in the manner required by law. Evidence में documentary evidence से related, secondary evidence, direct evidence, इस तरीके के topics काफ़ी important हैं. No person shall be appointed by the state government as a public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate. This list is prepared by district magistrate in consultation with Chief Justice of High Court, Chief Justice of India, Sessions Judge, Judge of the High Court, Judge of the High Court, and the correct answer is D. That is section 24 of CRPC is talking about it. That list has to be prepared with the consultation of Judge of the High Court only. Public prosecutor's list is being prepared. So that panel of names has to be prepared by District Magistrate with reference to Judge of the High Court. अब इसके लिए वो Chief Justice of India के पास तो नहीं जाएगा. 24 of CRPC you can refer public prosecutors. Under CRPC it is found out that wrong court has decided the suit. Then what will happen to the order that is passed by the court? Order shall be set aside, order shall be void, order shall not be set aside. Order shall not be set aside unless it appears that such error has caused some failure of justice. Suit shall be tried again. Answer is A. Order shall be set aside. Section 462 of CRPC is talking about proceedings in wrong place. If such kind of proceeding takes place, then that order will immediately be set aside directly as per section 462 of CRPC. This kind of order has been discussed. You can see in CRPC such kind of questions are asked a lot. Conceptual one was cognizable offence. Other questions were all relating to number of courts, public prosecutors, how they are selected, who does that. Then in such case, how will the order exist, substitute or set aside, jurisdictional questions. इस तरीके के questions आपको CRPC में देखने को मिल सकते हैं. Impleading an unnecessary party to a suit is non-joinder, misjoinder, joinder of necessary parties, joinder of parties, joinder of proper parties. Now, unnecessary party, this word itself suggests that the misjoinder of parties has taken place. Very easy question, but this concept is important, this chapter is important. Misjoinder of parties, non-joinder of parties, proper party, formal party, necessary party, all these concepts should be very clear from CPC. Now we have discussed all the set of questions that have come from 4 papers, phase 1, phase 2 of 2020 and 2022 memory based papers. You can also check out other questions and other videos. अगर आपने अभी तक बाकी के questions security law, company law, constitution, contract के नहीं check किए हैं, so do check it out by going into the videos of Legal B channel, and also don't forget to subscribe and visit website for free mock tests. Also there is a flat 50% off that is going on. नवरात्रि special offer है. अगर आपको सेबी का ऑनलाइन कोर्स चाहिए या कोई भी एग्जामिनेशंस के लिए, iXamB has various courses available and exactly 50% off is there. So you can go and avail it and also prepare 50% faster with iXamB. Thank you so much.